All right, hello CUNA. So this actually is more generally for Ada County. It's not within the city limits. This is regarding Powers Butte. It's a pretty large solar facility. I believe it's 200 megawatts. Actually, I can pull it up here. This is 250 megawatts, so it's fairly large. Um, and up to 200 megawatts 4-hour battery energy storage system in Canyon and Ada counties. This is their, if you want to see more details directly on the website, it's powersbutteenergycenter.com. In terms of the location, it's it's southwest of CUNA. So here, I think this map shows it better. So that little dot is CUNA, and this is Melba. So it's closer here. It doesn't really affect the city limits directly, but this is more of an informational, I guess, video for those in Ada County, and you could generally apply this to the city as well. You just need to look at their forms. So just taking a look, the first thing is you check the zoning of it. There's like zoning maps. You can Google and look at where the actual plot of the land is. And in this case, it is zoned RR. And so then you take a look at the county codes, and here you can see what the allowed uses are. You have principal permitted and accessory. Typically, those don't require public hearings. It's the conditional use hearings that are the ones that will interest you. In this case, I believe this is a centralized power facility. You see here that there are two noted footnotes here. Number 2, allowed outside areas of city impacts. And then number 4, allowed on irrigation districts and or canal companies' existing seasonal irrigation canals or ditches. In the case of RR, rural residential, you can see here it requires a conditional use permit. Now, the other thing when I try to look up under solar, they do have solar here. Let me see if I can find that. Distributed power facility, solar rooftop. And this one requires, this is the letter A, which is an accessory use. I'm not exactly sure how they choose between the two, but based off of the fact of the the amount of publication they're doing, like they're actually contacting neighbors, they're probably having to do a public hearing. I can't imagine why they would be advertising all of this without bringing attention to this if the neighbors really can't stop them. So I'm guessing this is going to go to a conditional use hearing, which is going to go before the Ada County Commissioners, and on the Canyon side, it's going to go before the Canyon County Commissioners. So there is a process for them before they can even do the application. They need to also have a pre-application conference. Now, the reason why I went through this process myself to create a subdivision in Ada County in the areas unincorporated outside of the city of CUNA, the limits. It was within its impact zone. So the city of CUNA got first crack, but as we saw here within with the code here, they cannot be within the city impact area, which is why they have to go so far away. So here you can see a little bit more as well regarding what power facility restrictions are. Centralized power facility, distributed power facility right here. And you can see general standards regarding the line. And this is one of the reasons why I think it's related to the solar part, because here you can see they have specific standards regarding solar application right here. So additional standards for certain centralized power facilities. Here you have hydroelectric, and then here solar facilities. So solar equipment shall meet the required setbacks of the Rural Preservation District. All solar panels shall be non-reflective. And see specific standards for certain distributed power facilities. Here it is. Non-reflective, they're not going to be roof mounted. Ground and pole shall be prohibited in the required front or side area. Pole solar equipment shall not exceed a maximum height of 15 feet. Pole solar equipment shall be set back 1.5 feet from the property line for every 1 foot of maximum height or the minimum setback for the district, whichever is greater. Ground solar equipment shall meet the minimum setback for the district in which it is located. I believe in rural residential it's about 30 feet. 30 feet or 50 feet. And then, yep, that's pretty much, these are some of the regulations. So what is the process for them? They're going to go, they have this pre-application. They get this checklist. You can just type conditional use checklist in in Google Ada County, and it should come up, and then you can actually read what they actually have to go through with whoever is assigned the Ada County planner assigned to the project. And then they have to go through this. There's additional requirements for that. They need a site plan. They need a neighborhood meeting certification. So that is done through. So when you look at the, let me see if I can pull up. That was just a picture. Oh, and how did I find out about this? There is a Facebook group called Stop Solar on Idaho's Agricultural Ground, Powers Butte Energy Center. That's how I heard about this project. So it looks like from there, that's where I heard that they're contacting neighbors. Likely what they're trying to do. The developers, they're within the zone here. Let me see, where's that map that shows here? This is probably the better one here, because I'm not really, Canyon County has its own process. I don't know specifically about that, but for Ada County, on the Ada County side, what they'll do is they'll do like a gray area. What you'll see this in the informational packet that shows where all the neighbor notifications. So I think it might be 1,000 feet from the borders. So all the neighbors will receive some kind of letter in the mail saying that there's going to be a neighborhood meeting. They have to do the neighborhood meeting before they even schedule the hearing. Once they submit the completed application, which you saw right here is part of the checklist with the planner, whoever the planner is, then they have to then that's when they schedule the hearing before the Planning and Zoning Commission, who don't have any final authority. They just do a recommendation for approval or a recommendation against approval, or they ask more questions, and I guess they can kind of table the issue, and then that gets passed on to the county commissioners, in which they either approve or disapprove it. Now, keep in mind, in all of these things, they're required by state law. They cannot just arbitrarily approve or disapprove applications. So they need to have specific findings of law, which is why it's important to review these regulations, safety concerns. I guess when you're dealing with more dense subdivisions and school districts, those can be or detriment to the community or to the neighbors, and then trying to get those addressed. That's why the solar panel company, which is what I guess Savion is working on this, which is why they're reaching all of the neighbors within that, let's say 1,000 foot zone, because they don't want them. Because every single complaint, if you write a letter to the planning, whoever the planning department is who's working on this project, it goes right into the public record, including your personal phone numbers and emails if you're putting that in on the sign-up sheet. Just keep that in mind when you have that neighborhood meeting. It's all going to be public information. So and all of these issues have to be addressed. And the reason why is if you bring up a legitimate concern that is addressed, you refer to specific code, right? That it might be in violation or it's not addressing. That can be, and if it's not addressed by the developer or addressed by the commissioners in one of the conditions, right? It's a conditional use permit. Then it opens up liability at the court levels for a judge to be able to overturn it because that issue was not addressed. This happened with Boise. There was a development there, and it ended up getting sent back. But it was regarding. I have a video on that. I got to publish it once there's like a slow day and no news is coming up. So anyway, let's see here. I'm just trying to see here if there's anything specific about solar panels. So there is no special checklist for that. It's just this one page for the conditional use checklist. Once they get it in regarding the meeting certification, then they're gonna do it. So that is, if there's noise concerns, they can put that in the conditional use permit. These are, you want to be as specific to the law, looking in the law as specifically as possible. So if you want to say like noise should be one of the issues, then you can take a look. You can use a search function here and just type in noise. Let's see what the here noise chapter 13 or noise control. Noises. So if you're concerned that the noise would be between 10 p.m. and 7 a.m., right? These are prohibited. You can be specific about that and mention that. And so these are specific. These are things that you can deal with. I guess blinding lights, that's been kind of resolved. So because they can't be reflective. So I mean that's it. I mean generally speaking, it's going to be very difficult. I did a video, I think it was last week or 2 weeks ago. Even with the city of Kuna, they didn't want a certain subdivision, but because they had in their future planning map zoning, it already had mixed use in there. So when the developer wanted to, increase the density of usage, they really had no legal reason to say no, and it just opens up legal liability because you better believe the developer there, right, who spent whatever millions of dollars with the space to buy the land up, and like you can't apply for a permit for, well, I guess you could apply for land you don't own, but they probably already own the land. I'm not going to look at Ada County land records, but I would assume that if you were to click on all of these areas, you would see that they pretty much own everything, because you can't apply for a conditional use permit on land that you don't own. I mean, the landowner would have to sign off on it. I think maybe you could apply, but without the landowner's signature, I don't think they would even hear the case, or it wouldn't go past the application. So I hope that helps you guys. If you're, they call this, so another way to look at this is they call this NIMBY, which is not in my backyard. And so that's what kind of the developers understand this, the commissioners understand this, and the developers know this, and the planning department, they know this. The people within that affected area, they don't want it. Not in my backyard, or NIMBY. And because Idaho is so strong with the property rights and the right of individuals. Now you say, oh, they're companies. I mean, that's a different discussion. But a lot of people own land in companies, and they're saying, you need to bring up a very solid reason, and supported by code. And if you can't do it, in all likelihood, it's going to pass. Now, one other thing you can do if you're, which I don't think I've really ever seen, is you can try and delay it, and tie it up in courts and try it that way. But you're going to be spending tens of thousands of dollars just to delay a project that in the end will probably get approved anyway, because they're gonna try and work with it, and we already see that there are a lot of other solar projects happening in the area. But anyway, I hope this helps you guys get a better understanding, and how the people who everybody's perspective on this. Yeah, so generally speaking, Savion, they want to make everybody happy, and like even in the project, the subdivision that I was doing, like even if one neighbor is complaining about something, I want to address that concern, because there cannot be, I do not want any lingering concerns that can open up to liability. Because let's say I'm the developer, the last thing they want is a multi-year long lawsuit that delays the process, because some of the neighbors are mad at that. And that's what happened with the Boise subdivision, where one of the other subdivisions next door, they sued based off of I guess the fire substation, there was not enough fire coverage and it wasn't addressed. It wasn't really addressed. It was just kind of this lingering issue. So every single complaint, every written complaint, if you go up in public testimony, that complaint, every single complaint must be addressed to the extent that it is covered in law. So in my case, there was concern that in the driveway, like, when you turn the headlights would affect like one of my neighbors on the other side, or might cause traffic concerns. So then you need traffic studies that would cover that. And then regarding light coverage, like saying, okay, well, as the developer, I will pay for privacy lights, or build a certain wall so that the headlights don't disturb them at certain times. Or you show with science that the lumens at X number of distance and at a certain angle offset would provide minimal lumens to cause any sort of disturbance. But still, I had as the developer, you want to address this. And let's say I didn't, maybe you just as the developer's perspective, you just don't want to leave any loose ends hanging, and that's why they're going through the effort of contacting all the neighbors to make sure they're happy or address whatever concerns. You're probably not going to be able to stop the project completely, but you have a lot of power in terms of making sure they, whatever your concerns are, that they try to address it and make certain compromises. So regarding the noise, I think those specific things regarding noise, I'm not too familiar on, but that'll be part of the discussion that you can have with Savion and figure out some solutions. Each neighbor is going to have a different concern depending on where they're at. Merely saying that it's going to be an eyesore, the developer may, and I've seen this in other projects, they may even say, you know what, I will plant a row of trees just for you. I mean, it depends on what the cost would be associated with it. We'll build tree row or cover the fence or something so that you don't see whatever they say, kind of an eyesore, so to speak. So these are things that you can address. I don't know, what is that? Is that like a power substation? Okay, so maybe like the noise of the substation. Maybe you need to take a research. What are the noise requirements on that? You would need to have like some kind of noise measurer, some data on other substations, depending on how many megawatts it's handling. I mean, there's different ways you can go at this if that is the concern. But regarding the noise thing, only like maybe this neighbor will be able to bring that up. If they're not near a substation, maybe they're not really going to be able to be concerned about that. Now, what they could do is, you see that they have substations here and here. Maybe they just say, okay, well, we'll move the substation closer into the center, and then they do a redesign of this. Yeah, I'm not sure if there seems to be kind of a house here. So maybe if this neighbor complained, they would redesign and move the substation here. But that's only if you bring it up. Then now that they have no basis for the noise complaint, I believe right here is a distribution facility. So this is a low resolution. But anyway, that's Canyon County, so they're going to have to deal with that side of things. Okay, so that's about it. All right, have a good one. Bye-bye.